Hello, my name is Peter Bricks. I'm a debtor bankruptcy attorney in Atlanta, Georgia. I also have offices in Woodstock, Cumming, Jonesboro, and Dunwoody. Uh, I'm here to talk to you today about motions to lift stay in bankruptcy, but first I want to issue this brief disclaimer. We're a debt relief agency proudly assisting consumers in filing bankruptcy under the U.S. Bankruptcy Code. However, we'd have to meet with you individually to offer you applicable and accurate legal advice. There's no attorney-client relationship with the viewer of this message. This is intended strictly for educational purposes. So, motion to lift stay in bankruptcy. Why is this important? Well, a lot of times I'll wind up filing a case for someone who is on the eve of a foreclosure, repossession, a garnishment, something. There's immediacy to the case filing. If there's to the person, there's immediacy to the case filing, and they're not what's called a serial filer. They get the automatic stay, and that's very important to them because it prevents creditors from taking certain collection efforts. Now, of course, there are some who don't really have any immediacy to their actions. They're even current on all their payments. They're just overwhelmed with debt. Even to those people, they get the automatic stay, but to them it might not be as important as someone who's trying to stop a foreclosure or garnishment. So the automatic stay would take effect, again, assuming not a serial filer, and that stops all creditor actions. So if a creditor wants to take an action during the pendency of the case to repossess their collateral, for example, they're going to have to file what's called a motion to lift stay. They're asking the bankruptcy court, Your Honor, we would like the stay lifted. It's not fair. Well, what would be a reason it's not fair? It's going to vary by chapter. Chapter 7 is not a repayment chapter, so if you're not current on your mortgage and therefore the bank is, you're in arrears, your bankruptcy stopped the foreclosure, so you're not in the chapter that devises a repayment plan. They're going to say, Your Honor, they're not in the chapter to repay me, so I don't care that they can potentially pay month to month going forward. They're in arrears. They're not devising a way to pay the arrears. We need the stay lifted, not to collect against any debt, not to sue them for a deficiency. We know we can't do that in Chapter 7. This is just to go at our collateral, repossess the home. Now, in that instance, as long as there's not an issue with their standing or something, it's presumably going to be granted because you're not current. All that being said, just because the automatic stay is granted by the bank doesn't mean they're going to instantly send you a foreclosure notice. In fact, a typical Chapter 7, if there's not a liquidation, not any particular issues with the discharge of a debt, it's going to last about 4 months. And the stay is going to expire then when the case discharges and closes if it's on a path like that. So the stay doesn't even stay in effect that long. Therefore, getting the automatic stay lifted in month 3 isn't necessarily putting the creditor all that much ahead on the timeline there'd be if they just didn't take any action. So the creditor now gets the stay lifted, and then the creditor might at that point initiate a foreclosure. However, my point is, just because they do it, they might not even initiate a foreclosure at all, or if they do, they might not do it till 2 months after the case ended when the stay was already expired anyway. So if you're in a debt or in bankruptcy and you get that motion to lift stay on your home and you're in Chapter 7, don't just assume you need to be out tomorrow, because all they're doing is asking the bankruptcy court for permission to foreclose according to state law. Same thing could happen with a car. You're in arrears on your car when you filed the bankruptcy. That would be an example. Now, garnishment would be a little different in Chapter 7 because really there wouldn't be a reason that you would get a stay lifted to continue to pursue a garnishment, because the reason you're pursuing a garnishment is actually to collect a debt, a monetary debt, as opposed to the car and the house, which was to just repossess collateral and not collect a debt. I know it might seem unusual to you that when someone's trying to repossess your house, they're not really collecting a debt, they're really just getting collateral. Now, Chapter 13 is going to be different because whereas in Chapter 7 is a mortgage, if you're in arrears, you're not proposing a repayment plan, the bank could immediately file a lift stay and presumably get it granted. In Chapter 13, you're proposing to pay those arrears. You have a repayment plan. So since you have that repayment plan, unless you default, and you also are obligated to pay the ongoing mortgage now going forward, your repayment plan, now this will vary by district, but at least in the Northern District of Georgia, your repayment plan is to the trustee, your arrears are covered in your trustee payment. Your ongoing mortgage payment is separately paid to the bank. So in that scenario, unless you default on your ongoing mortgage payment or the trustee payment, they're not going to have a lift stay granted because you're current on your Chapter 13 obligations, which include repaying the debt. So that's really how it's different in Chapter 13 with a car payment. This will also vary by district. I know in the Northern District of Georgia, your car payment, and this is unlike the mortgage payment, your whole car payment is going to be paid as part of your trustee payment. So as long as you're current on your trustee payment, the debtor, I mean the creditor is getting paid, and they wouldn't have a reason to object to the lift stay. So in your repayment plan, you're going to propose how to treat them. You might adjust their interest rate, for example. Their remedy, if they think their interest rate is too low or you're doing what's called a cram down and adjusting the principal balance, their remedy in that scenario is not to file a lift stay, it's to object to the terms of the plan. And then the judge will determine whether your principal balance is too low or your interest rate's too low, and then you would need to adjust it accordingly in your repayment plan, but that would not be a motion to lift stay. So that covers motions to